everyone. So welcome and thank you for coming to our event, Merits and Mistakes of the Misconduct Model Rule, with Professor Josh Blackman and Professor Henderson. We're really glad to see all of you here, and if you haven't already, please take this opportunity to go get some food. We have Potbellies, there's some FedSoc merch, and we have a little sign-in sheet for you. If you have not yet become a member, this is a reminder, let me quickly pull this over, to become a member. This is just so that you can be in the group chat and to send your confirmation to our communications director, Grant, at gaw6@iu.edu. We'll also have this code up at the end of the event. 1Ls, this is also a reminder that the application for 1L representative is still open and will close this Friday at 11:59 p.m. We highly encourage you to take this opportunity just to become more invested in your community and to get a little bit of experience with FedSoc leadership. Our board will consider applications and then be giving you our decision on Monday. Now to our event. Today we will hear about ABA Model Rule 8.4G for our 1Ls who have not yet taken their ethics class, also known as Legal Profession 2. The American Bar Association has promulgated a set of ethical standards for lawyers that to varying extents has been adopted by the states. And we'll hear a little bit about how Indiana has handled 8.4G today from Professor Henderson. These standards prescribe appropriate conduct for lawyers carrying the threat of suspensions, disbarment, and other kinds of sanctions for violations. ABA Model Rule 8.4G specifically reads that it's professional misconduct for a lawyer to engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status, and conduct related to the practice of law. So going on to our speakers. Professor Josh Blackman is a professor of law at the South Texas College of Law, Houston, where he holds the Centennial Chair of Constitutional Law. Professor Blackman is a leading scholar on issues regarding constitutional law in the United States Supreme Court and has been cited over 1,000 times in law reviews across the country. Cited by Forbes magazine as one of Forbes' 30 under 30 in law and policy, he has been quoted during 2 presidential impeachment trials, testified before Congress, and regularly appears on news stations like CBS and NPR. Professor Blackman co-authored with Randy Barnett the casebook in front of you here, 100+ Supreme Court cases everyone should know, so stay tuned.
You didn't even take the plastic off.
I did not take the plastic off so that when we have our drawing, they can have a brand.
But can I sign it?
You can sign it.
Okay, we'll take the plastic off later.
Yeah, so we'll take the plastic off today, we'll sign it.
It's like grandma's couch, we'll take the plastic off.
And stay tuned for a drawing on that. All right, Professor Henderson is the Stephen F. Burns Professor of Law here at Maurer and holds a JD with honors from the University of Chicago Law School. Professor Henderson has been honored as one of the most influential figures in legal education, appearing on the National Law Journal's list of the 100 most influential lawyers in America and being named the most influential person in legal education by the National Jurist magazine in both 2015 and 2016. He's deeply involved in legal innovation and education reform and founded and is an editor of Legal Evolution, an applied research publication focusing on how the legal profession can evolve through innovation, and serves as the director of Maurer's Flannery Family Office Program. Please join me in giving Professor Blackman a warm welcome to Maurer and thanking our speakers for sharing their insights with us today.
Thank you so much. Okay, who here is taking professional responsibility? Okay, about half of you. So you will soon take a class that is very important. Lawyers have a lot of ethical obligations. You have duty of candor to the court. You have duty of confidentiality to your client. You have fiduciary duties, as you have to manage your client's funds in an appropriate fashion. You can't steal client funds. But historically, the bar associations have regulated the practice of law. What you do in a court, what you do with a client, what you do before a tribunal, and so on. The topic of today's lecture is a little bit different. It's not just about regulating the practice of law or professional conduct. It's at regulating conduct related to the practice of law. Conduct related to the practice of law. And according to the comment, it says this includes participating in bar association functions, Social activities connected to the practice of law. What can you not do? Engage in conduct that you know or reasonably should know is harassment on the basis of race, sex, national origin, disability, sexual orientation, gender identity, marital status, and socioeconomic status is, I guess, how much money a person has. If this was simply a rule that said you can't harass people in court or for a legal proceeding, I'd have no problem. If there's a rule that says you can't discriminate in employment at your law firm, no problem there. That's also against Title VII. There are household laws about this. But what makes this proposed rule different is its scope. It applies to conduct related to the practice of law, at social activities related to law, any type of speech that's harassing. Now, what does harassment mean? You have some excellent professors in the room. Maybe we'll take employment law or labor law. There's an established body of law of what sexual harassment might mean. Severe and pervasive conduct and of sexual nature. There's a body of case law on here. But the term harassment by itself is a little bit trickier to define. Does it mean something that bothers you? Something that offends you? Something that troubles you? Does that have to be severe and pervasive, or could a single comment suffice? In 2016, the American Bar Association put out this proposed rule, 8.4G. And the numbering is actually not that important. In different states, the numbering will be different. Now, Indiana has one that actually predates 2016. Maybe we'll talk about that later. But the ABA put this rule out in 2016. And they said, okay, states, adopt this rule. Historically, ABA model rules have been adopted pretty uniformly. In fact, I haven't said the Indiana rules of conduct, but it's probably very similar to the model rules, more or less. That bill, yeah. Most states track the ABA. But for a host of reasons, this rule proved to be controversial. We're now sitting here almost 9 years later, and this has not been adopted in 50 states, not even close to it. Many states have rejected the rule outright. Some states considered it and withdrew it after a comment period. Some states had a comment period, never acted upon. They've been sitting around for years. At least a couple states, including Texas, where I live, have declared this rule is unconstitutional. Not just bad policy, a violation of the First Amendment. Vermont adopted in its entirety. Okay, so there's Vermont. A handful of states adopted more narrow versions of the rule. One of those was Pennsylvania. Curiously, a judge in Pennsylvania declared the rule unconstitutional. That was then reversed and appealed because they found there was no standing, there was no threat of enforcement. But Pennsylvania still modified the rule further. So this is a curious topic to talk about because I think it was a well-meaning rule, and I think the people enacting this were acting in good faith. They were trying to stop what they saw as a problem of harassment and discrimination among lawyers. But I think they stepped a bit too far. So I want to talk about 4 categories of items today. First, I want to talk about how the bar is extending its jurisdiction to conduct that's related to the practice of law. This would include lectures at a CLE dinner, dinner time conversation at a bar association function. Even this lecture right here could be considered conduct related to the practice of law, getting credit, maybe get CLEs for it. Okay. The risk is that when you start extending the bar's reach, you have a chilling of speech, that people may be afraid to speak on matters of public concern. The rule and the comments didn't really understand this threat, and in many regards, they sort of dismissed it. Second, I'll talk a bit about how 8.4G differed from previous regimes, such as Indiana's. Most rules historically have respected the practice of law. This goes a few steps beyond that. Third, I want to talk about the First Amendment implications. There is no professional conduct exception to the First Amendment. There might have been in the past, but the current court doesn't have that view. There have been cases about doctors and other professions where even though you're speaking professionally, you still have a wide range of speech. And I think you have to look at it like this. Where is the government's power of regulation the strongest for professionals? When the professional is engaging in the core of his profession. So as you have a more of a distance, an attenuation from where lawyers are speaking in courts and the forums, when you go further to private social functions, the state's interest in regulating is less. And the fourth, I'll talk about some of the state-by-state breakdowns of the law. All right. So why was this rule adopted? And again, I think it's well-meaning. If you read through the testimony of the ABA commission that drafted it, they gave, I think, frankly, very sad stories. Imagine a Christmas party at a law firm where a senior partner is sexually harassing a junior associate. There was testimony that a partner said to an associate, after dinner, come to my hotel room, right? In a limousine after a company holiday party, sexual overtures were made. Not good. No one thinks that these are useful and good things that should be happening. What they were trying to do was say that if you're engaging in sexual harassment as a lawyer, not just in court, but in social functions related to your job, that itself should be actionable under this rule. And I think it's a matter of Title VII, maybe Steve can correct me. If you are a senior partner and you ask your subordinate into your bedroom after a company holiday party, that's under Title VII, I would think, right? So this stuff that's already covered by employment law, I think, in the federal government and all 50 states. But they want to take a step further. The people that drafted this rule want to signal that we as lawyers take our profession seriously. And that we want to be sort of beacons to the world. We want to show that we are doing by word and deed, that not only will the people do this be hit with a Title VII judgment, they'll be hit with a misconduct complaint, right? You can settle a Title VII case. You can make that go away, right? You just throw some money at it, and in these cases, settle. But if your law license is suspended, okay, then you can't make more money. So I think their concern was about sexual harassment. But when you go from sexual harassment to harassment, we have an issue. So what does harassment mean? Okay. Harassment is defined in the rules to include demeaning or derogatory activity. Demeaning or derogatory activity. Okay, what does that mean? We're all lawyers here, we can look up dictionaries. Demeaning is where you make someone feel less than their worth, right? Derogatory has a similar connotation. Again, this is not the same thing as propositioning an associate for sex or firing someone because of their race. It's making a comment that can be reasonably viewed as demeaning and derogatory. So, you know what? I'll give you a couple examples. Race. Let's say I'm at a bar function or a CLE event and I give a speech about affirmative action. And I say, I agree with students with fair admissions. I agree with the case. And let's say that I argue in favor of mismatch theory. They did that when people are admitted to a school through affirmative action that they are not able to attend. Otherwise, they might do well academically and they might actually flunk out. Could that be seen as demeaning and derogatory based on race? Probably. A lot of people are very, very upset by the concept of mismatch theory. We could do one on gender. Let's say that women should not be eligible for the draft. Someone says that because they're physically incapable of doing so. That's a view on public concern. It's an issue people debate publicly, but it might be viewed as something that triggers liability. All right. Let's say I talk about disability. Let's say people with mental handicap should be eligible for the death penalty. That even with these handicaps, they still knew what they did. Sexual orientation. I get up here and I say, a Berger-Felby Hodgson was wrong and gay marriage was immoral. Let's say if I say that. Could that be viewed as demeaning and derogatory? Probably. Gender identity. Talk about bathrooms, athletics, a host of other topics. Could these be viewed as demeaning and derogatory? Again, it's not just that you are saying, I am not going to employ you because you are gay, you're a transgender person. That's already covered by a host of other laws. It's speech that could be demeaning to people because of these views. Now, we'll get into intent later, whether you intended to do so. The ABA rule itself is a little bit cagey about the mens rea. Okay? You have to just know, or reasonably should know, that someone could find the remarks disparaging. Okay. Had they limited this rule to just the actual practice of law, again, I think I'd have a hard time making some of these arguments, but they want to sweep more broadly. Now, what about the First Amendment? What's curious is that the drafters of this rule didn't really consider the First Amendment. An earlier version said, this rule does not apply to conduct protected by the First Amendment. And that comment was later dropped out. Right? They actually removed a comment that would express protected free speech. Why they do that? They said they want to avoid ambiguities. I don't know. But they took it out. All right. Now, the First Amendment analysis here focuses very much on chilling effects of speech. Now, who's taking First Amendment free speech classes? Okay. In the First Amendment context, there are two broad categories of speech. What's called a prior restraint of speech, and then what you might call punching after the fact. If you say something that, say, is defamatory for someone, you can be held liable. If I defame you, you can sue me for a tort, right? Defamation. If I incite imminent violence, I can be arrested for inciting violence, right? There are categories of speeches that are not protected, and you can punish people for it afterwards. But there's another way of restricting speech, which is called a prior restraint. It's saying that you can't say something in advance. There's actually a bar that if you say this, you'll be punished. You'll be subject to punishment. Now, most people, unlike me, don't have academic tenure. We have tenure. Steve, Bill, and I, we have tenure. We're good. Say whatever the hell we want, right? It's good to be the king. But if you don't have tenure, you face risks by speaking out publicly. And you might say, well, you know, I like my job. I like not being in jail. I don't want to lose my law license, right? I'm going to self-censor. I'm not going to speak. I'm going to keep my mouth shut. I'm going to chill my speech. This is a concept of chilling speech. You self-censor. And I'm sure you all done this before. You're sitting in class like, man, I really want to make this comment, but I'm going to put my hand down. I never had that issue. My hand was always up. Speak freely. It's very important, especially with these professors. You got a good culture of free speech here. I mean that sincerely. Not everywhere. I can't say that old schools, but here I think a good culture of free speech, especially with Steve. So this concept of chilling speech. So there's a lawyer in Philadelphia, a guy named Greenberg. He works for FIRE, which is the Foundation for Individual Rights and now Expression was Education. And he actually brought a lawsuit against 8.4G. And he argued that he goes and he speaks on matters of public concern, on issues of transgender rights, sexual orientation, domestic violence. He speaks on a lot of issues. And he said, I worry that if I were to give a speech or a CLE or a bar function event, that I might be subject to discipline. So he brought a lawsuit in the Eastern District of Pennsylvania. And the biggest issue actually wasn't even the merits. The biggest issue was standing. Anyone taken federal courts yet? So usually you can't just go to federal court and complain about something you don't like, right? That's not how it works. You have to have an injury, or at least a credible fear of injury. So the key issue in this case was, did Greenberg, this lawyer, actually face a credible threat of prosecution? Right? Was there going to be an enforcement action taken against him under this rule? The trial court found that there was. And the trial court found that, yes, the Pennsylvania bar is likely to take steps to punish him, and that would be a violation of the First Amendment, and there, in fact, was an injury. Curiously, on appeal, Pennsylvania sort of changed course. And they basically said, no, we interpret the rule to not apply to these circumstances. They basically conceded, I'm being somewhat hesitant because they didn't actually say this, but they basically conceded that CLEs and bar functions and the like would be protected speech. And this is in some ways a retreat from what the ABA had said, and which is actually fine, right? Pennsylvania can modify their rule. And in fact, they sort of modified it on the fly during the course of litigation. Not the best way of running a bar association, but hey, it happens. And they were able to convince the Third Circuit that there was no credible risk of any action being taken against Mr. Greenberg, therefore the case went away. So the only way then they could save the law was basically to eliminate the objection that I and others had raised to it. All right. So where are we? In almost every state that has considered 8.4G in the wake of 2016, they've either rejected it or adopted a variation of it. And I think this reflects sort of a bigger societal trend, right? What institutions exist to sort of police our speech, right? Should our remarks be constrained by fears of demeaning or being derogatory towards others? And I think it's perhaps a noble idea in the abstract that we should be willing to use the power of the bar, willing to use the enforcement power of these bar associations to try to nudge people towards a certain way of thinking and speaking. But in practice, it hasn't worked out. I think there's been a very broad hostility, a very broad opposition to this. I want to read to Judge Kenny, who was a judge in Philadelphia. He said, "There is no doubt that the government is acting with beneficent intentions. However, in doing so, the government has created a rule that promotes a government-favored viewpoint monologue and creates a pathway for its handpicked arbiters to determine, without any concrete standard, who and what offends. This leaves the door wide open for them to determine what is bias and prejudice, based on whether the viewpoint expressed is socially and politically acceptable, and within the bounds of permissible cultural parlance. Yet the government cannot set its standards by legislating diplomatic speech, because although it embarks upon a friendly, favorable tide, this tide sweeps us all along the admonished minority viewpoint into the massive currents of suppression and repression. Our limited constitutional government was designed to protect the individual's right to speak freely, including those individuals expressing words or ideas we abhor." So I think I'll wrap up on this point. We are all either attorneys or attorneys in training. I think we need to be very careful with how we use the power that we're given by this license. But by the same token, we need to allow people to say things that you may not find savory and that you may find offensive and demeaning or derogatory. And the way to respond to them is by countering their speech and not by trying to censor them and take away their license. All right, thank you so much. I'll sit down. Let Professor Henderson come up and welcome your questions.
Hey, everyone. It's really a privilege to share the podium with Josh Blackman. You've been incredibly prolific and very creative in your work. I admire it from afar here. I would say that we operate in different lanes in the legal profession thing, not ideologically at all, but in terms of the areas we focus. I do mostly applied work. I do teach professional responsibility, but I'm not a First Amendment guy, and you go deep into the weeds of this topic here in a very admirable way. And I don't really disagree with anything you presented today. I wanted to provide just a little bit of context. So knowing that I get to share the podium with Josh, and what value can I add here? Well, first I got to get up to speed here. So I go and I go into the ABA model rule annotations, and I look to see what are the cases that have come about through 8.4G. And then I learned a little bit about the history of the rule here. So I know I got a bunch of 1Ls here. So I'm going to just give you some kind of basic features here. So the model rules of professional conduct are created by the American Bar Association, and it's done by all the several states coming together, lawyers and judges and law professors to put forth rules of professional conduct that can be adopted state by state. And so each state has the discretion to adopt the model rules. As Josh pointed out here, almost every state adopts some variation, of it, but then they get revised over time here, and a state may decide, and to be clear here, it's the state Supreme Court that decides whether they want to adopt this rule or or not. And so just to give you a little bit of a background, I was surprised when I went into the annotations and learned about the history of this one. Typically, I will give 8.4 G a gloss when I teach professional responsibility or the legal profession here at Indiana, but now I'll probably do an Indiana specific version of it because it was kind of interesting. So 8.4 had a comment in it. So the rule that Josh is talking about was adopted by the American Bar Association that has no authority here. It's just a group of professors, lawyers, and judges that are getting together to say this is what the model should be here, and we encourage all states to adopt it. That happened in 2016. Well, what was the state of the art in 2000 and in the late 1990s and before 2016? There was a comment in 8.4, and 8.4 covers professional misconduct, and there was a commentary in it that talked about harassing comments or derogatory, disparaging comments. Without specificity, without listing the long list of different categories of discrimination, but to say that would be prejudicial to the administration of justice. And so when the committee that was revising the model rules got together here, they said, should we take comment 3 to model rule 8.4? Should we elevate it because we care so much about this invidious conduct or people discriminating? And you were talking about when Josh was talking about hearing about these standards, they went through these parade of horrible stories, and the story of a young lawyer that's invited back to a room, completely. I mean, it's bad on so many levels, but probably actionable on other levels. Certainly actionable on levels besides that one here. But sometimes lawyers want to. The purpose of writing a rule is expressive. It's to say to condemn a category of action and maybe to nudge society to change the norm in their particular direction. But let me give you the history of what happened in Indiana. So Indiana, in 2005, the state of Indiana, a committee that put this on the radar screen at the Supreme Court said, we think we should have a rule called 8.4G, and they wanted to elevate 8.4, the comment in 8.4 that was specifically pointing at 8.4D. So let me just tell you what 8.4D is, and this is pretty much on the books in every state here. Did I leave my glasses? There are my glasses. There we go. Okay, 8.4G talks about it is professional misconduct for a lawyer to engage in conduct that's prejudicial to the administration of justice. And the comment 3 was specifically talking about words that would be gratuitous, that would be insulting to folks here, and they wanted to elevate it and make that a comment G. So when these kids, and believe it or not, here when you go and you look at the Indiana Rule 8.4G here, Indiana comprises about half the annotations, and so it's been litigated in Indiana on several things. So let me read you the text of the two rules that are in place here, because 8.4 is almost always matched up with 4.4, and so 4.4 is your conduct in the practice of law, engaging with other parties, and so the Indiana rules prohibit the following misconduct. 4.4A, using means and representing a client that have no substantial purpose other than to harass a third party. And Josh was talking about specifically in the practice of law. That's really where this rule is applying here. And then 8.4G, and this is the Indiana rule. Engaging in conduct in a professional capacity manifesting bias or prejudice based upon national origin and or socioeconomic status, and this conduct was not legitimate advocacy. So in the realm of the current language, but having no scienter requirement, we're basically intent requirement, just like if you utter a word that's disparaging, that has no legitimate purpose, that's prejudicial to the administration of justice, or you can be sanctioned. And believe it or not, I think that I may be using that to just say this is the state of the law in Indiana here. So 8.4G, our version of it, was adopted in 2005, and there's 5 cases in the annotations about it here with attorneys getting sanctioned and having their licenses suspended for, say, 30 days in some cases. One of them was a racial slur using the N-word. One of them was an anti-Semitic comment characterizing a whole group of people regarding their business activities. One was a gratuitous reference to someone's sexual orientation, and 2 pertain to immigration status, gratuitously. And when they came before, and the way Indiana works is you go before a trial judge or an appellate judge, and they review your file here, and they make a recommendation to the Supreme Court. And all of these cases resulted in sanctions of the attorneys. They were pretty straight up. It's just like, what are you doing here? This is the administration of justice here, and this is insulting to people that are parties in the litigation here. Why are you doing this? And typically they would go easy on you if you apologized. And only one of the cases that I read did not involve an apology. And you look at this lawyer and you think to yourself, this guy is mentally unhinged. And so I want to kind of wrap up here with there's something going on. I think I want to separate out, and I do agree with Josh, when the ABA adopts this rule, and it does raise some First Amendment concerns. I think it was an expressive activity by the ABA committee doing it here. It raises the rule, and the states have to decide whether they're going to adopt it. It hasn't been adopted by hardly any state, but has it generated a lot of law review articles. and so that this is not really law in practice in many jurisdictions. It's a professional group or self-regulated profession pushing the version of law, what they think the law should be, but the state's choosing not to adopt it. And so I guess kind of where I come off on this one would be, it seems like Indiana's rule is working pretty good. It's on the books. It's different than the ABA model rules, but I think that if we went through these different fact patterns, we think, yeah, that's a good outcome, because the lawyers really were engaging in things that were insulting to parties and completely were not advancing the ball. And I think that and all of these opinions were either 1 page or 2 pages long here. So Josh, you gave me a lot to think about, and I think that maybe Steve would have been a better person to specifically talk about the First Amendment, because I think this raises First Amendment expressive issues. But I really appreciate the opportunity to talk with you.
Yeah. Let me add a few more thoughts about why this became so controversial. So Bill made a fair point. He said that very often when lawyers pass rules, there's an expressive aspect to it. It's not just that we pass these because we think they'll be actually enforced. In fact, the best rule is something that will never be enforced, because it just sort of states what is so obvious that people say, of course we're going to follow it, right? We're going to aspire to this goal. And if you read a lot of the model rules, even the canons of judicial ethics, they're aspirational. It's like, here what we aspire to. This rule, I think, was caught up in controversy from the outset. And this will get a little political, but not too much, I promise. I think it was because most of the people working this rule were on one side of the spectrum. They were on the political left. There's not much of a mystery about this. And they thought, and I think they're well-intentioned, that this rule would be uncontroversial, that how could you object to a rule that bars harassment and discrimination? But if you go through the deliberations, there were many comments submitted to this committee, and they sort of just brushed them aside. So, we don't have to worry about that, right? Basically, trust us, right? The bar, right? The state bar, the state ethics agency, they will enforce this with a degree of common sense such that we will not be punishing people for engaging in speech. But a lot of conservatives, in particular religious conservatives, saw, wait a minute, we have this rule. And it says that if we say something demeaning on the basis of race or religion or sexual orientation, we can lose our law license. And the Christian Legal Society and other groups just got very, very worried about this. And this went on, as Bill said, for a decade. I wrote 2 articles since myself. I gave up. I said, all right, I'm not afraid about this. So I think this might actually be a lesson of how to actually get rules passed. And maybe the Indiana model is a good model for the nation. right? If you actually have a rule that's targeted to the problem at hand, and you're not simply trying to, I won't say virtue signal, but trying to just signal what you're trying to accomplish, it's more likely to be there. And there's not a trust us aspect to it. But unfortunately, this rule has just been mired in so many controversies, it was mostly dead on arrival. A bigger issue, and I'll pivot a bit, is to what extent is the bar useful to engage in political grievances? So we saw in the wake of January 6th and in the wake of the 2020 election, many bar associations punishing Rudy Giuliani and Jeffrey Clark and John Eastman for the work advising President Trump on the election and on the January 6th incident. People have lost their law license for this. And putting aside whether, in fact, these lawyers, in fact, violated the rules of professional misconduct, it creates the sense that the law is being used in a politicized fashion. And I think whenever you have what's supposed to be a neutral agency, the American Bar Association or the state bar is being viewed as only opposing one side of the spectrum, it makes it harder to get things done. I'll give you another example. The American Bar Association is currently the accreditor of law schools in just about every state. That's not written in stone. And just this past week, Texas, my home state, put out a proposed rule saying, ABA, you'll no longer be the accreditor. We're going to take over. And why are they doing that? Again, it's a perception that there's been this sort of ideological drift and that there's the group that has most people on the left, not the right, and we don't want to do this. So I kind of like FedSoc events for a lot of reasons, one of which is people who don't agree come together and find common points of agreement. And I think had the committee that put together Rule 8.4G taken more steps of outreach back in 2015 and 14, it would have been adopted probably widely. I think this was not a process done well. All right, I will pause there and I welcome any of your questions. Thank you so much. You can clap. That's okay.
All right, if anyone has questions, just kind of signify whether you're directing it to Professor Henderson, Professor Blackman, or to them both.
Steve, go ahead. Yes.
So
He's so funny.
The concept of harassment based on some kind of protected status has got to be one of the most heavily frequently litigated issues there is. Lots of judicial opinions. And my understanding of that area of law, I don't teach Title VII, but usually there's a limiting principle. It's that like an offhand remark doesn't count. It has to be severe
Correct.
and pervasive. So I'm just checking Indiana University, and I suspect most other public universities has language pretty much identical to what you've talked about. It's a prohibited harassment. It gives examples of harassment like offensive remarks and all that. But because universities under the First Amendment can't have speech codes, there's a limiting principle that basically says it has to be harassment of a kind or a level that essentially precludes somebody from getting the benefits of education. Again, sort of like it has to be so severe and pervasive that it doesn't just offend you subjectively, like no reasonable person could stand it and you'd have to withdraw or something like that. So are you saying there's no limiting principle implicit in the rule, in the ADA rules? But if there were, let's say through judicial gloss, there was that kind of limiting principle. Well, the ABA rule can't just mean making one offensive comment at a party. It has to be severe, pervasive, prevent someone from, I don't know how you would state the equivalent of, preventing somebody from accessing the benefits of education in the legal context. But if you could put some kind of limiting principle on it like that, would you still object to it?
So this is why Steve and I are good friends. That was exactly proposed. So I proposed expressly that a severe pervasive requirement should be added to the rule. I made that point in a dozen comments in various states. The problem, and Professor Sanders nailed on the head as usual, there is no severe pervasive requirement. So in the employment context, let's say that you and I are coworkers, and one day you hear an offhand racial comment, right, or an offhand sexual comment. It was a one-time thing. Maybe someone's having a bad day. Maybe they just screwed up. And you know what? I'm really sorry. I screwed up. That is probably not what's called a hostile or offensive work environment. But let's say every day you come to work and they make a racial comment and make a sexual comment. It's pervasive. It's every day. Okay. Then that gives rise to a claim. The severe one's a little bit harder because severe might be a single remark that is so egregious, so horrible that it just shocks the conscience. That might be enough also. I don't know what that's going to be. I'm not sure, so I'm not going to say it here, right? So employment law has dealt with this to avoid the offhand comment. So if I show up and I give a Celia address and I'm giving a one-time speech, you've never seen me before, we have no relationship, I make a single comment in an hour-long remark that becomes demeaning. Under the rule, Steve, yes, that could be enough. So I propose in a number of comments to various state and other bar associations, you need to have a severe pervasive requirement. In fact, no one did it. Oh, you know what? At least one state rejected 8.4G because it didn't have the severe pervasive. They cited me for that. I can't remember which state that was, but it was one of the states. So thank you, state. Eugene Volk, interestingly enough, thought that wasn't enough. Eugene thought even severe pervasive wouldn't save it. He thought it was still unconstitutional. But I went along with Steve, say we can maybe find a middle ground somewhere. And the key point is, Bill mentioned scienter before. That's the mens rea, the intention. If you know or should know something is demeaning, right? There's both objective and subjective. You think of the tort standard, right? Man, I'm pretty chastened. Do I think things are offensive? No, but would a fresh wide-eyed first-year law student think it's offensive? Probably. So even who's your audience, right? A lot depends on the subjective intent. So Steve, I'm with you 110%, but I think the failure. Now you mentioned judicial gloss, and it's a concept that maybe 1Ls haven't been accustomed to yet. Very often courts will say, well, this is maybe unconstitutional, but we can read it in a way to save it. And, sometimes you have a First Amendment case where the Supreme Court imposes an intent requirement, a specific intent requirement. So you could have specific intent. In the Pennsylvania case I mentioned a few moments ago, Pennsylvania basically said, yeah, that's what the rule says, but we won't enforce it here. We give you basically our promise. They actually had an affidavit signed by the chief disciplinary officer saying, we will not enforce in these contexts. And that was enough for the court to say, look, they've come out and said, we will not enforce this against you. They don't ever do that. And that was enough. So whether it's judicial gloss or judicial Josh, whatever it is, I think there are ways around it. Very good question, Steve. What other questions we have? Bill, go ahead.
I wanted to pick up on the you were alluding to the not too political, but talking about the potential for different people losing their license for what they did, and state bar associations going after people to pull their bar license for things that they did related to the 2020 election. I teach professional responsibility for 15 years, and I will start with the preamble. And in the preamble, it talks about us being public citizens and having to educate the public in order to maintain the rule of law, because our constitutional democracy depends upon faith in these institutions, and that and this is the reason why we're regulated by the judiciary, because we have a special public purpose. And I'm just going to state this is my pure view. I don't think that we've ever lived up to that as lawyers. And I think that for a lot of different reasons here, where if you look at lawyers' careers here, most of the time we're kind of taking care of our own careers here, and we'll go to different meetings and we'll nod, yeah, this is important, this is important. But if everybody's responsible for something, nobody's responsible for it. And here we find ourselves, and I don't think this is just the way it is that we had a riot that was on the Capitol. Was it an insurrection? I'm not sure if it rose to that level here, but it was not good. And we had a lot of evidence that the people were using using frivolous pleadings, or what would be arguably frivolous pleadings, in order to use the legal system to give tactical advantages to sway a national election. Now, do I think it's going back to specifically to your point, Josh? Do I think it was wise for states, for bar associations to go after Rudy and a few other lawyers to do this one here? I wish we had taken action a lot sooner. We didn't have I really feel like we are reaping what we sow from our society got to the point where a good portion of the populace wanted to burn the system down, and they rushed the Capitol. And there's populist fervor that's in place here. But, Josh, I'll put this question to you. We're now at a point, and this is current events, where there was an election, one party won, and they're implementing what appears to be a new way to use the Department of Justice. And there was a Eastern District U.S. attorney that was told by the President of the United States, or there's evidence of this, to just say, we want you to go after my former FBI director. And the FBI director and this person was basically fired. They found somebody, an appointee to temporary or kind of acting Eastern District of Virginia attorney that went into court the other day with a 1.5 page complaint here to indict Jim Comey. Now I'm wondering what happens if a federal judge basically says that they feel like this person has been, it's not the Bar Association, it's a federal judge say, what are you doing in court? And it may turn out a different way, Josh, I don't know, but it could be that the federal judge refers that person to their Bar Association. Says what you're doing is you're abdicating your duty to be an officer of the court here about what the conduct you're engaging in here. I guess that's a more extreme behavior. I mean, I'd like you to parse a little bit the kind of the state taking these issues up. Maybe it wasn't a great idea versus a federal judge referring somebody because they're falling short of in the judge's eyes, they're falling short of their duty of being an officer of the court.
Oh, so much good stuff there. Let me go a few things. So, who's taking criminal law? You're taking it now? Okay. So in our system, to obtain a criminal charge on a felony, what's called an indictment. An indictment means you present the case for what's called a grand jury. You have a petite jury, that's a small jury, and a grand jury, which is a big jury. That was it 23 people in most states? And you need basically close to a majority of the grand jury. You need unanimous. In criminal conviction, you need a unanimous jury verdict, usually. But for grand jury, you don't. And in the last, 8 months or so, there have been a number of attempts to indict people that have not succeeded. So perhaps one of the biggest manifestations in D.C., people who have basically attacked federal officers in D.C. have been charged not with misdemeanors, but with actually felonies. Like one guy threw a sandwich at a federal officer in D.C. I think he was probably drunk and just lost his mind, but he did it. Don't throw sandwiches at federal officers. Bad idea. Now, there's an old expression, you can indict a ham sandwich. This was actually a salami sandwich. But they couldn't indict the guy. No bill was returned. Now, is it because that the DOJ is overcharging or because the members of the DC grand jury resisted? In the Comey case that Bill mentioned a moment ago, they actually had several charges, one of which had a no bill. They couldn't indict all the charges. Now, I have a perspective on this that might not be well known, but maybe you know. But I was involved in a lot of the special counsel litigation. President Trump was indicted a lot. He got indicted, let's make him run through them all. He was indicted in New York City, and the charge was, and I'm going to try and say this without grossing you out, that he authorized the payment of hush money to a porn star. Did I get that? Is that good? Right. So basically, Stormy Daniels is a porn star. He had an affair with her. Trump authorized hush money to be sent through his lawyer, Michael Cohen, to Stormy Daniels to keep her quiet. And the district attorney in New York brought an indictment. By the way, the federal prosecutor in New York didn't bring the charge so that it wouldn't stick. But the New York prosecutor brought the charge on this very creative, elaborate theory of campaign finance law. I'm still not even trying to understand it. And he was able to secure an indictment. He was also charged by the New York Attorney General in a civil matter for basically overvaluing his real estate, basically not quite lying, but puffing to the various real estate companies of how much your property is worth. There was the indictment in Georgia for election interference and calling up, say, we need some more votes to be found. Then there was the litigation by Jack Smith. There was an indictment in District of Columbia, not for insurrection, but a related charge. There's also the indictment in South Florida for storing documents in Mar-a-Lago and related things. Trump got indicted basically a lot. And then we have the insurrection case, which I was involved in way too much, where several states tried to take Trump off the ballot. Even in Colorado, the Colorado Supreme Court took him off the ballot. All this was going on, I'm like, wow, this lawfare is problematic. It's going to suck when you guys are out of power. And so it is. So, President Trump, I don't speak for him. I don't know how he approaches things, but he's not a lawyer. right? He's not going to approach with magnanimity. He's like, look, I got indicted, I got screwed, I got shafted every minute while I was out of power. Your turn. So I see we're in this kind of a vicious cycle, right? They tried to disbar Rudy. They tried to disbar John Eastman. I'm sure there'll be efforts to disbar liberals. Not good. Not good. I don't know how we can break out of this cycle of lawfare. I actually don't know. And even if some of these claims have merit, you don't have to use the legal process for everything. Political processes sometimes do work to solve problems. So I don't think I answered your question at all, Bill. But maybe
I think we got a point of
yeah.
agreement here I think prudentially, it might have been a good idea to take a pass. If you're looking for outcome-driven things here, you want to bring the country back from the precipice. I think in hindsight, it's just like as you call it, lawfare. Is that the tactically right thing to do here? Lawyers have a ton of discretion here, and sometimes we don't. We have too much faith that we'll get an outcome in court here. That's oftentimes not the right thing for broader society.
Yeah, I agree with that.
We should channel ourselves into the political process.
Yeah, I think we agree in law. Sarah, we out of time? I think we're just about done.
We have just a few minutes.
Any non-professor questions? I love my professor question. A student question. Yes, sir, over there.
I chuckled a little bit earlier when you said that this university has a great free speech.
I meant this law school. I think the law school is actually I was referring to.
Oh, okay. You mentioned. Okay.
Yeah. No, I know Steve's had some issues with the university.
Right. Okay. Yeah. Then you're aware. Okay.
No, I know, but I think. But am I correct? This law school is pretty good.
Yeah.
Yeah. No, I think I've been to this law school many times. We've done debates on some pretty heavy topics over the years. We have never had a protest. I've been protested. I've been heckled. I've been shouted down. You guys are lovely. You know, you're not throwing any sandwiches at me, man. I'm doing good.
Well, and the federal judge did strike down IU's policies. But yeah, just the fact that IU tried to have the policies.
Yeah, the state legislation. That was the. Yeah. Well, I should update my remarks. Fair enough. I'll say something better next time. But look, my point is, I'm here. No one's heckling me. No one's shouting me down. I'm happy. Okay, maybe one more question before we run out of time. Yes, over there.
So you were discussing that other people have other ways to take action. You mentioned Title VII, but could one benefit of 8.4 be that the state judiciary can independently take action against partners?
Yes. Well, I don't say it's a benefit, but it's definitely a feature, right? In order to bring a Title VII complaint, you must be an employee at the firm or someone related to the firm. Basically, anyone can bring a misconduct complaint. Like if I'm just sitting in a ballroom and I overhear a comment, that might be enough. And that lack of privity, if you will, that lack of relationship is actually what makes this rule so problematic. Same with judicial misconduct, right? You maybe don't know this. Anyone can file a misconduct complaint against a judge, not just the party before the judge. So if I learn a judge did something I don't like, I can send a complaint. So anyone can do it. So I don't call it a benefit, but it's a feature. Maybe one more question for a little more time. That was a short one. Yes, right over there.
Can you explain how this rule might implicate social media posts? I know you mentioned how much it extends beyond the professional capacity.
So yeah, this is a huge issue. I'll take maybe one more minute to describe this. If we say conduct related to the practice of law, almost all law firms have social media presences, right? They'll have Instagram, they'll have TikTok, they'll have stuff promoting it. And what if they put something on social media that someone finds offensive? That's related to legal practice. The harder one is actually the comment thread, because let's say a lawyer has a Facebook post or something, right? And people putting garbage in their comment threads. Are you then now liable to take down stuff that could be imputed to your law firm? That's actually the trickier one. All right, I think we're out. Thank you all so much. I appreciate being here. Thank you so much.